All right, I think we're going to get started. So I am Cindy Lott. I am the academic director and also a full-time senior lecturer here at Columbia University School of Professional Studies. And many, many faces are familiar to me in this room from all walks, which is lovely. But we are so happy to have you here for this masterclass this evening. I'm going to tell you a little bit about our program, not a lot, because we want to get to the meat of the program that we're going to be discussing with our esteemed panel here. But I also would like you, and I'm glad that so many people came for the networking event. I love nothing more than to see our students and our prospective students talking to people that have been out in the field in whatever your particular world is within this field of the nonprofit sector, or the charitable sector, whatever it is that you do in it. It's wonderful to see that interdisciplinary mix of folks, and it's something that I've really enjoyed in my career over the years. So I appreciate that all of you are here. So a very quick overview. This is the master's degree in the nonprofit management program at the School of Professional Studies. Every single semester, we've had this program now for 2 years. The curriculum that I designed, and I oversee the program and have amazing faculty that have stuck with this program, and our associate instructors also that are here. We have about 200 students in this program and are having alumni graduate every single year. We have a broad range of classes that we undertake in teaching every single semester, fall, spring, and summer. So we welcome any inquiries about that. In addition to our curriculum, we offer all sorts of other different types of programming that goes on, just like tonight. And so once a semester, we have a master class that is intended to bring luminaries to our campus who are not otherwise associated with the program, and to be able to offer that up to our Columbia community, to our students, to our prospects, and also to alumni and anyone else that is interested in this particular field and gets a chance to come for free, network, interact with each other, and enjoy an evening of lots of erudite discussion. So that's on you guys. You're the erudite part tonight. So tonight's topic, it was great that the International Charities Regulator Group was already going to be here at Columbia. I have a long-standing association with state charities regulators and also some at the federal level, which is how I've met virtually all of these folks in one capacity or another. And they are here for 2.5 days, I believe, having a conference, courtesy of the New York AG's office, Jim Sheehan, who is representative of that office, and Columbia. So we're happy to welcome them here, and took advantage of that fact and decided that this would be our master class this year. There are so many issues happening on the globalization front, even around everything, right? Every single sector. But the charitable sector is not immune from that either. Technology in particular makes all of us much closer these days internationally. But philanthropy is very global now. And particularly for our younger folks, they don't think twice about texting to give, whether it's Haiti or China that's having the earthquake, or any other type of humanitarian disaster that may be happening elsewhere in the world, civil strife, terrorism, political issues. We have all sorts of issues, and they are rife with human need that our sector, the charitable sector, reacts to and wants to do something about. And with that, that means that we also need regulation and enforcement around some of those issues too. So this raises the issues around what are we seeing now that has become more to the forefront. It isn't that this is brand new by any stretch. We're going to have someone address that actually. But we are seeing much more in terms of how the regulators are thinking about this collegially, and how they're thinking about working together, or what are the challenges and the barriers in working. So this evening, our topic, as you see, charities regulation on the international front, emerging issues in globalization. And we're going to take it on a couple of fronts. We're going to first take it on the front of substantive areas that we're seeing being dealt with at this point. And then we're going to discuss what some of those challenges, what those barriers are, what could be some efficiencies that are built in, and what keeps countries from being able to work on some of the issues that are definitely transnational, right? So I have here an esteemed group. All of their bios are available. You're also welcome to the PowerPoint slides that are being presented here tonight that Jim Sheehan has. There's a taker, it sounds like. We gotcha. So other than that, we have no other slides, but we do have a couple of things that you might be interested in over the course of the evening. This is being webcast, just so you know. We will have an affirmative presentation from all of our panelists here, and then we will be doing Q&A. And I'm happy to have all of you ask whatever it is you'd like. In addition, we have other international regulators in the audience, and we would love nothing more than to hear you weigh in also if there's something that's particularly striking or pertinent to your jurisdiction. So with that, I'm going to do a very quick introduction of all of these folks. I'm going to start at the end here, the one person that I had not met until this evening, but we have been talking over email, and this is Sarah Atkinson. And you want to introduce where you're from?
So I'm Sarah Atkinson. I'm Director of Policy Planning and Communications for the Charity Commission for England and Wales.
Thank you. And we do not have Tony Manconi tonight on the dais, but he's in the audience, which I appreciate. So we hope that we'll hear from Tony at some point later tonight from Canada. And next is Ruth Madrigal. And Ruth is now at Steptoe and Johnson, but she was with the Department of Treasury for a very long time. Anything else you'd like to add? We go back now at this point.
Ex-Treasury.
Ex-Treasury. There you go. Mark Owens?
I'm Mark Owens. I'm a lawyer in private practice dealing with charity law. And before that, I was director of the Exempt Organizations Division of the Internal Revenue Service. So I, in essence, left the government and walked around to the other side of the table.
And most importantly, has been a long-time volunteer with all of the work that our charities regulation projects have done. And next to Mark is Jim Sheehan from the New York Attorney General's office.
Head of the Charities Bureau.
Yes, head of Charities Bureau. So my work, in addition to being an administrator of the program and teaching in the program, is that I do charitable regulatory policy is my area of research. And I have had the great fortune of working with three, and now I'm so happy to add a fourth here. And I have done some work in and around the international charities regulators as well. And I am thrilled to say that when they gather in a place like this to really talk face to face and then be able to report out what it is that they are doing together, this is a huge moment. It is not every day, by the way, that regulators actually get together in a room. We learned that a long time ago with the program that I ran at the law school, the National State Attorneys General program. It really matters when people can share information when they're dealing in different jurisdictions. So I am really, really pleased that all of the charities regulators have been able to come together and do this, and they've got another day and a half after this. So I know it's been a long day. All right, so we are going to start, as I said, with a number of substantive issues before we get into some of the challenges and barriers. But we're going to start first off with Mark Owens, who, as he mentioned, had been at the IRS and was the head of the Exempt Organizations Division for a very long time. And Mark is going to discuss from his long-standing observation, but also participation in the sector, about what it looked like back when and what it looks like now in terms of charities regulators either working together or not, as the case may be.
Thank you, Cindy, and good evening, everyone. In the roster of attendees here, there was a common denominator among all the regulators, and that is we are from common law jurisdictions, which means that our source of charity law, whether it is morphed into a tax-based system the way it has in the United States and to a certain extent in Australia, and Canada has its own amalgam of oversight, is all based on what began in England many, many years ago, as far back as 1601, with a statute of charitable uses that set out what was appropriate behavior for charities at that time in England. And England led the way with regulation, creating the Charities Commission of England and Wales in, I think, 1853, sort of a first effort at regulation. And since then, each of the common law jurisdictions represented here tonight have tended to sort of go their own way for a variety of reasons. The United States obviously had a dispute with Great Britain at one point. And at that time, there was no Internal Revenue Service in the United States, particularly in the new United States. But the interest in severing the ties with Great Britain were such that the various states decided to simply eliminate any vestige of English law present. So they wiped the law books clean of all English precedent, and then decided to build it up again as time went along. And it was discovered that there were answers to problems that had existed for a long time in charity regulation. But each jurisdiction sort of went on its own path, taking the same basic understandings of what is charity law, what's good, what's bad, and then moved in their own way in their own jurisdiction. And that, while that is useful in dealing with the law in the insular state in which it arises, it doesn't do too much for coordination. So the history of interactions, at least from the United States perspective, and the United States perspective would be that, we are the biggest and the best, ergo everybody should follow our lead, was basically that of the interactions were looking at case-related, discrete kinds of issues. So interactions between regulatory bodies, the United States and other common law jurisdictions, the United States and other non-common law jurisdictions, occurred at a couple of levels. One level was enforcement. It was very case-related activity, and for years that's been going on. Charities, charity oversight by the tax regulator in the United States began in 1913 with the creation of the Internal Revenue Code. U.S. charities were already active outside the United States at that time. The Rockefeller Foundation in 1913 began a major effort at funding healthcare reforms around the world. In 1914, they created the China Medical Bureau to create the first Western hospital in what was then Peking, China. So there's a history of international activity, a history of, from the regulatory standpoint, of each jurisdiction sort of moving its own direction, not necessarily talking to others, but then obviously a need to speak and coordinate arose fairly quickly. So the coordination level would occur on a case-by-case, enforcement-related basis. It would occur as a result of tax treaties. A typical provision in a U.S. tax treaty with a foreign country has the Internal Revenue Service enforcing administrative summonses for information. I had one hapless client who got sideways with the French government and received a summons from the Internal Revenue Service for its books and records on behalf of the government of France. So there's that case-related coordination occurs. There is also, and historically there has been a sort of what I'll call a visitation process where delegations would come typically to Washington, not so much going the other direction. Once again, it's this sort of insular idea of United States predominance. But those interactions, interesting enough, were not with common law jurisdictions. They were with jurisdictions in which the legal tradition was not deeply developed. And so they would come to the United States to see how oversight occurred, and then they would often visit some of the other common law jurisdictions. So there was that sort of international cooperation effort, but not on a case-related basis. And then there was some fairly significant discrete casework going on from time to time. That began to change about 15 years ago, thanks to Canada, which began this tradition of meeting of the international regulators getting together and meeting once a year. I think it was once a year, at least it was initially. And that tradition, I think, allows for a better exchange of ideas and discussion. And one of the things we'll be talking about later on is why that's critically important, that the flow of money is being facilitated, it's been made easier, and it might not even be money these days. It might be Bitcoin or something of that nature. So these conversations are extremely important to have occur so that people have contact information, each other's contact information, and do in fact contact each other.
Excellent. Thank you for setting the stage, Mark. We're so grateful that you're here and have the long-term perspective on this. We'll hear from Mark again later this evening. Next, very, very grateful that we've got Jim Sheehan here from the New York Attorney General's Charities Bureau and is also hosting the conference this year. Jim, do you want to take the podium? It's here. It's here.
Excellent.
We're full service.
You do a great job. And thank you to Cindy for
Francis.
organizing this. One of the challenges in following Mark Owens and is that he started off in 1601 and worked his way up through 1913 to a client that got sideways with the French government in the space of 10 minutes. And we're just humble people here in New York. I don't know if you can tell that.
Some
And
of you
so-
are.
We learn from cases, and so I want to talk to you a little bit about two issues. I wanted to do three, but Cindy only gave me 10 minutes, so I had to cut one off, which is world peace. So the two issues I want to talk about are the issue of the Catholic Church and international cooperation, and the second issue is money laundering and international cooperation. So if we look at the Catholic Church, one of the things that the New York Attorney General's office is doing this year, and probably for a number of years in the future, is an investigation of the 8 dioceses in New York to see how they handled the issue of sexual abuse by priests of minors. And the concern here is not just what the priest did, but how the hierarchy, the charity, right, because they are charities, responded to the problems that were raised. And so we looked around to say, okay, this is the common law tradition, what have other people done in this space? And so we started off with the John Jay College clergy study, which was commissioned by the bishops, but is a pretty good product. And they say 4% of the priests had sex with minors, and that's based upon their own surveys. And then we looked around other countries, and who's doing a good job in terms of analyzing both the problem, the scope of the problem, and then thinking about what are the appropriate remedies going forward. What should we do to address this issue going forward? And I guess I can pick out favorites here, right? Australia did the best job. They did 5 years of a royal commission, and the product, and if you go on their website, the commission's website, and look at the report, it talks about how it arose, how it was addressed, very careful listening to the victims, very careful listening to the other members of the public who are concerned, and coming up with an approach that, in our First Amendment world may not be fully what we can adopt, but gave us a lesson about how to do it. The next one was in Ireland, where the Murphy Report, which I thought may be related to the Charities organization there, but I learned today is not, looked at these issues in 2009, and there's also a separate commission to inquire into child abuse, not just in the church, but in other organizations that had responsibility for children. The next thing, I guess it's not international, it is the next state, the Pennsylvania Grand Jury Report, which came out this year. And we also looked at Germany, which has a report that came out this year. And one of the great things about looking at these reports from a variety of different jurisdictions with different legal systems and different autonomy for church organizations is, what did they find? To what extent was the problem local? To what extent was the problem national? To what extent was the problem with the universal church? And unfortunately, if you look at these reports collectively, what you are led to is this is a problem for the institution as a whole. And I think the lesson of that is you can't do one diocese, you can't do one parish, you have to focus on how the organization responded. So you'll say, and Cindy asked us to talk about international cooperation. And in this area, it is mostly asking people for information about how it was handled in their jurisdiction and how do you protect victims? How do you deal with the due process rights of priests who are accused? How do you deal with the bishops and how they responded? And these may sound like legal issues, but they're human issues. And learning how other people dealt with them over the last 10 years has been very, very helpful in forming our thinking on that issue. So Catholic Church investigations, there are victims, there are perpetrators. But the big issue that we see over and over is the institutional responses. The next set of issues, again, looking at the literature, was it's not just about diocesan clergy. A number of problems arose with what are called institutes, which are Christian Brothers, Jesuits, other organizations which exist outside the hierarchy and the structure of the diocesan authority. Reform and reconciliation. What systems work? Should we adopt a South African system where we have this come out and people say what happened? We'll be satisfied with that. The church has started some of these things. Do they work? How should they work? What are the expectations? And the final issue that we had to deal with is the issue of canon law and the Vatican. All right, so canon law is an entirely separate legal system, although if you've seen professional discipline systems, you've seen canon law, whether it's lawyers or doctors, it looks very similar. And to what extent do you respect the autonomy of the organization? To what extent do you say, I'm sorry, the canon law 487 cannot apply in this circumstance, civil law controls? So all these issues, again, we talk to our colleagues in other countries, the systems are different, but the issues are very similar. Next issue. So having talked about Catholics, now I want to talk about money laundering. And the one thing I've learned I'm sorry, whoops, Vatican Bank, never mind. The issue with money laundering, and when you're a lawyer, sometimes you meet with a client and you don't know the whole subject when you promise to do something, and then you start to research and say, oh my God, what have I got myself into? So here's the first thing to know about money laundering. Nobody cares. All right? I'm going to say, people care about money laundering when the money moves out of their country. When it comes into their country, it's a great thing. So let's suppose you are selling, let's say you're selling condominiums in New York City. Just pick a area at random. And a bunch of Russians show up with cash. All right? Do you turn them away? The real estate brokers turn them away? The lawyers turn them away? And the answer is, one of the things about the United States, we have different states have very different cultural traditions. So in Boston and Philadelphia, they are theocracies, right? What does God want? What's the right thing to do? New York never bothered with any of that stuff. We're about money, right? So the prostitutes and pirates would show up in New York City being turned away from Philly and Boston. They were welcomed because they had money. So we have the same system here now for money laundering. And so let me see how far I'm going to go with this.
We're all wondering.
So if you think about where do you put money that is dirty and in a way that is going to allow you to get it out at the other end and it'll be clean. And real estate is great, and we'll talk about exactly why in a minute. But what's happened that's not on my slide. So the G7 Financial Action Task Force, I'll get there in a moment. So let's talk about the real estate transactions. So when the Patriot Act was passed, which is a statute after 9/11 that says we want to have anti-money laundering controls in financial institutions, there were two critical groups that they left out of the statute. And this will shock you: real estate brokers and attorneys. All right? Must be because that's the right thing to do. And escrow agents, I didn't talk about them. But one of the things that happened is that they left them out and they said, we're going to pass regulations in 2003. Well, it's never happened yet. So then the question, in the last couple of years, what has happened is the Department of Treasury said, we really want reports on residential purchases because 30% of the apartments between 57th Street and 42nd Street, there's nobody living in them. Right? How could that, the new buildings, how could that be? But they started making records of who's buying the stuff for cash. Meaning no mortgages, no financing. So what we're finding now in New York is that there's a movement away from residential properties to charitable properties. Now, if you think about this, it's the perfect area if you're going to be in the money laundering business to do, right? You can make a donation to the seller charity. Religious properties in New York, there are thousands of them. They've mostly been in single ownership for a long time. And the properties in various states of repair, and they're houses of worship, conferences, retreat centers. And there's very limited records about what these properties are worth. There's no tax assessments because they're exempt from taxes. There's no income statements because they're exempt from taxes. They've had one owner. Trinity Church has had the same owner since they stole it from the Dutch in 1660. I'm sorry, stole. Did I say stole? The acquisition. So if you're going to launder money and you can't do it in residential real estate anymore, what a great area. So I said, people will be excited about this. They aren't, right? Because the money moving in is overall a plus. So that's the real estate piece. What we're starting to see is activity and investors. And you say, we're told this guy's worth $1 billion. He doesn't exist on the internet, right? There are like 3 places this guy exists, and in a business that, could be magical, but he's $1 billion to invest. So that, again, so we went to our federal brethren and say, you're excited about this? They said no. But I will say, I remember I talked about the international organization that oversees money laundering. It's money laundering and terrorist financing. In 2018 and 2019, guess what country is the president of that organization? The United States. And that organization is primarily focused on terrorist financing and weapons of mass destruction, which is fair, but the money laundering piece is not an area of interest. Next piece, international contributions. So I'm a charity in the United States, and you can only deduct money for in our tax system for exempt U.S. organizations, including private foundations. But one group does not need to file any statements with the IRS, right? Their money can come in and go out without anybody looking at it either way. And there's no anti-money laundering for churches. Donor-advised funds, in theory, there's a reporting system, but they're totally outside the money laundering world, right? So banks have these requirements, brokerage houses, financial institutions, but not donor-advised funds. So if you're thinking about laundering money, this is advice, sort of like getting crossways. This is advice. What you need to do is to think about what organizations don't have to comply with the anti-money laundering structure. And that's churches, religious organizations, and donor-advised funds. And so what we see is money going to the charity and then going out to another country and then circling back, all right? So, and you take a fee of about 7 or 8%. Now, being able to tell you this is how it works from talking to witnesses is very different from being able to prove it in court. But the issue is the structure of our statutes allows religious organizations and donor-advised funds to be very helpful conduits for the money laundering activity that occurs. And the offshore reporting basically doesn't exist, right? It's just not there, not effective. Am I doing on time? Okay, so that's my speech. Catholic Church abuse, good thing. Good thing to go after it. Help from other countries. Money laundering, bad thing. Nobody wants to work on it if the money's coming into their country. That's, I tell you to do 3 points. The third point is influentials list. So if you are, we think we do a very good job in the Charities Bureau of informing and educating our public on what we do and why we do it. We have an influentials list, so if you finish tonight and think this is really cool, give us your business card, and we will put you on our influentials list. And if you have questions about this presentation, that's my email. Thank you.
That's great, Jim. So I know that I see some of my students' eyes going, oh yeah, we've talked about this in class, right? It's real, and it's big. And would you say that it's more than ever, or it's come to prominence and the awareness more than ever?
Let me just say that the controls on money laundering within the United States, I've talked to my friends who do enforcement and do defense. The defense lawyers are very unhappy. You know why? There are no cases. The enforcement people are very unhappy. You know why? There are no cases. So but I think it's a significant issue, and I think the real estate part of it is significant too.
All right. Well, we're going to have lots of time at the end for Q&A as well. So we're next going to hear from Sarah. Yes? Sarah Atkinson. Again, some about sexual abuse scandals, but also some more about some other international and issues in dealing with aid organizations, et cetera. So thank you.
So like Jim, I'm going to reflect on some issues prompted by some real-life case and investigation issues. We're the charity regulator for England and Wales. So charity law, there isn't a UK charity regulator. Sometimes we get labelled as the UK charity regulator, but we have colleagues in Scotland and in Northern Ireland. Charity law is devolved in Scotland and in Northern Ireland. So the UK, 3 charity regulators already before you even start going outside the UK boundaries to talk about international. So cooperation across regulators is our daily bread and butter. I'm going to share some reflections that when Cindy asked me to do this was the first thought that came into mind on this topic, which is prompted by some cases that may have been familiar to some of you. around Oxfam, Save the Children International, and other issues that turned into a huge tsunami of issues around sexual abuse and harassment in the aid sector. It all started February this year, a front page article in the Times, which reported that Oxfam GB, charity registered with us, staff working in Haiti in 2010, including the country director in 2010 in Haiti, had used, it was first described as used prostitutes, had been paying young women in Haiti for sex whilst working on the aid relief situation. And that report and subsequent reports relating to Save the Children in the UK and allegations about the conduct of the chief executive and senior people in the charity, again involving sexual harassment, in this case of Save the Children staff, unleashed a whole series of reports and political concern and public attention centering on the fact, the well-known fact, but for the first time in a long time, the fact given lots of political and public attention, that there are widespread issues and concerns about sexual abuse and sexual harassment across the international aid sector. And this report and this response triggered a number of things that happened, including lots more conversations between us and our colleagues in Scotland and Northern Ireland about the UK reaction. It also triggered a select committee of our Parliament inquiry into the causes and the consequences of these issues. It triggered our Department for International Development that controls the UK aid budget, which of course doesn't all go to charities, goes to lots of organisations that are not charities. It triggered their investigation. They froze their funding to Oxfam and to Save the Children, really significant partners in delivering UK aid overseas. They set up an enormous global conference and brought partners from across the world to talk about setting standards and strengthening reporting and all manner of issues. And it triggered us, the Charity Commission for England and Wales, opening a statutory inquiry into each of those charities. And of course, those inquiries are still open and I can't talk about those specific cases. But what I can do is share some of the tricky international jurisdictional issues, capacity issues, and issues about operating in this kind of political and public challenging expectation, which already from what Jim has said have a lot of resonance and a lot of similarity. So first, capacity. We had, since this 20th of February article, we had 2,114 reports from charities registered in England and Wales of issues of safeguarding, concern or harm reported to us. So that's between 20th of February and 30th of September. That's 50% more than we'd had in the whole previous reporting year. And yet we don't think that's anything like the actual substance of issues that are taking place. As a third of those reports were from charities with objects to promote overseas aid, so where their full-time, full-on activity is overseas aid and international development. But it's still 1.5% of the charities on our register who've reported anything happening to us since 2014, and we don't believe that's because 98% of charities have not had any kind of incident or problem since 2014. We simply don't believe in the kinds of work that they do and the kinds of contexts they operate that is possible. So we know there are reports that are not coming to us. We know we don't have full knowledge, so we know we don't have full data, full ability to analyse trends, full ability to drive guidance or advice. We also know we're an organisation of just shy of 400 staff. We know if we got full reporting, what we think is probably the full extent of reporting, we could not begin to deal in terms of casework and action with all of those reports. So we have that fundamental dilemma. We need more reports because we need more information and we need the true picture, but we wouldn't be able to deal with the true picture if we were getting reported it. We've also, through this recent focus, been able to clarify our expectations about reporting, that we want charities to report to us the incidents in a timely fashion, that we want them to report incidents involving partners that they work with, that we want them to report incidents to us even when they take place outside the UK. But the reality of getting that kind of understanding, that kind of confidence in reporting, that kind of clarity of line of sight into the decision-making processes and the reporting processes of all the charities on our books, and the same for our colleagues in the other parts of the UK, is that we know we're barely scratching the surface. And of course, I talked about the organisations whose full-time, full-on job is operating internationally, but we also have many charities who have purposes to serve religion or education, who, as a tiny part of their activity, do a little bit of international visits. Maybe they send a couple of students, or maybe someone from the church goes, they support an orphanage. So they don't even think of themselves as operating in that kind of context, and yet they are absolutely operating across borders and putting themselves and people within their charity into those kind of challenging situations. So there's a capacity issue there. There's also an issue around powers, our remit, our framework. Our jurisdiction is limited to England and Wales. Our jurisdiction mirrors that of the High Court. So for overseas charities, for local partners who are not registered, we can hold the trustees of the charity that's registered with us to account, but we don't have that kind of direct remit over all of the activities and all of the operations. And in some of these complex environments, we're talking 2, 3, 4 stages worth of organisations, of money and responsibility moving. And as structures become more complex and decision-making moves out of the UK into the global south, which is exactly what should be happening in terms of international aid and development, that gets even harder. So Oxfam GB is part of Oxfam International. At the moment, both those organisations operate out of Oxford, because that's where Oxfam was first formed. But in the next couple of years, Oxfam International is moving to headquarter in Kenya. Oxfam GB stays in the UK and stays under our jurisdiction, but the group parent moves into Kenya. So we're talking about UK donors' money being spent in Yemen under the jurisdiction of Oxfam International, headquartered in Kenya, and perhaps being managed by staff who are Dutch, French, German nationals. And you can see the jurisdiction issues just mount up. Add to that different jurisdictions have got different bases for considering what's criminal, and add to that those capacity issues of whether we can have any kind of line of sight of these operations anyway, and you see the challenge. We learnt, incidentally, through this process, through these cases, that the National Criminal Agency in the UK does have some specific extraterritorial jurisdictions when UK nationals are involved. That wasn't widely known, and it certainly still is not widely understood across our regulated community of charities. So we've been able to highlight this in our guidance and our processes, but again, it's a long road to get that understood and to get the kind of reporting recognised. A couple of other things related to our powers and regulatory remit. The statutory framework for us exercising our powers of sanction largely relates to charity money, charity property. That's how things were framed. That's what it's about protecting. There's actually very little explicit reference to protecting people. We take the view that in the common law jurisdiction, protecting charities' assets includes responsibility to look after the people, the charity's reputation, the work of the charity. And we take the view, frankly, that protecting the people that a charity is helping, or the people that are working within a charity, is a natural corollary of the fiduciary duties that trustees have. Could get tested. We might turn out to be wrong about that. We don't have that explicit grounds, and so we would quite like explicit framework to rest on that charity people in themselves matter. We also don't have any statutory regime around reporting to us. It's clear that giving the Commission false information is an offence, but giving the Commission no information may not in fact be a breach. So again, we don't have the framework there to require those reports in the first place. And when charities do disclose to us sensitive material, where a whistleblower discloses to us sensitive material involving potentially criminal actions, we're a civil regulator. Our decisions are appealable in the charity tribunal. And of course, there aren't the same kind of protections over sensitive information that you would have in a criminal trial. So we can't guarantee that that kind of sensitive information is going to be held confidential. And that's a huge problem in the kind of issues we're dealing with. The third challenge for us is the expectations. Now, as I said, not all aid is UK aid is delivered by charities, but where it is delivered by charities and where we're talking about significant sums of money donated by the public and public funds from our own government, and combine that with a clear expectation expressed by our politicians and by our public at large that charities are expected to operate to the higher standards. Where an individual's conduct falls short of criminality, or where perhaps the way that a charity has chosen to deal with an issue is to manage the individual out, maybe not take the disciplinary processes all the way through. It's easier and better for the charity's programme if someone's managed out and it's pushed away. The interplay with those kind of different jurisdictions and the limit on our own ability to hold anyone to account that's not the UK trustees. You may have a gap between what anyone can enforce and what the public and the politicians expect should happen when these kinds of issues take place. In the International Development Select Committee inquiry that I talked about and I mentioned in the reading list, we made some suggestions about actually using the same Financial Action Task Force model that Jim talked about to look at a global cooperation of standards that governments could work to mutually apply in the space of safeguarding sexual harassment, abuse, other kinds of abuse of vulnerable beneficiaries. And the DFID, our aid organisation, is looking actively at that kind of model, perhaps an ombudsman model where there's a victim-centred approach to securing these issues. But that is a long game. Bringing the cultural change about where charities feel confident to report that things have gone wrong, and to acknowledge that getting to the bottom of these sorts of issues means that for a while things will look worse before they start to get better in the context of those kind of public expectations. That's probably the trickiest aspect of all of these. So we're at the start of exposing some uncomfortable truths about the way that our sector operates, and the need to rebuild that, as I say, may well involve things getting worse before they get better. Uncomfortable, but that's the reality of the environment we're in. No laughs in that one. Jim managed to get laughs out of Catholic sexual abuse, and I didn't get a single one. There we go.
Thank you, Sarah. So that raises all sorts of really interesting issues for me, and we can talk about some of these in the Q&A, particularly around the notion of beneficiaries, and thinking how fundamental that is on jurisdictional issues, since beneficiaries are typically in a different jurisdiction when we're talking on the international front, right, than where it's located, Oxford, et cetera. Also, on record is saying that intellectual property and branding and reputational branding is definitely an asset of nonprofits, and one that's incredibly undervalued over and over and over again. But it may be the actual legal hook you have. First, you have a proof problem, but then you have to get to the jurisdictional hook and thinking about, is it just the donor dollar that you're protecting? Well, but the donor dollar can't do its job unless it's getting to a beneficiary, and it can't do that often if it doesn't have the reputational branding that it set out to do. So that's a tough, attenuated argument, but I'm here to help you make it if you need it. So all of you who run nonprofits, pay attention to your IP, please. So we're gonna take questions on some of these really, really interesting issues and how some of the international communities either work together or, as I mentioned, not work together at times, and those barriers in a latter portion. We're going to talk briefly here. I'm going to ask both Mark, any of you, but Mark and Ruth particularly, to talk about terrorism. I know that Canada has particularly had some experience around this, and if anybody in the audience would like to talk about that as well, when we get to the Q&A, please do. But Ruth, having been at Department of Treasury, you certainly were exposed to all sorts of high-level issues like this in the last years. Thoughts about how that's being handled or not internationally?
Well, to be clear, at Treasury, I was in the Office of Tax Policy, which is where charities and charity policy is sort of done at the federal level. I'll talk more about that later. But the FinCEN, the folks at Treasury that really deal with terrorism, are up a floor and down the hall, and they. I don't think they had really had regular contact with the Office of Tax Policy and the charity person at the Office of Tax Policy until I'd been there about 4 years, and the State Department called me and said, we're having difficulty talking with the FinCEN people because we are interested in charitable activity abroad, and they're concerned about terrorist activity abroad. And can you come to our meeting and help mediate? And I have to tell you, that was one of the most uncomfortable meetings of my entire time at Treasury, with some of the most raised tempers, because there's a lot at stake, right? There's concern, and terrorism is a big problem. And as in one conversation I had with someone at the IRS is concerned as a regulator. I'm not sure that they're really their mandate is to stop terrorism, but they, at least at some points while I was there were a number of folks that felt that was part of their mandate. And they expressed to me the concern that, yes, it's rare, but if something bad happens, the harm is so great. People die. But from a charity policy perspective, I guess my sense is, but you know what, we deal with that risk every day and we ignore it, because if we don't do charity, then people die. Different people, maybe in a different place, but we have people dying on both sides of the equation. So I came to that meeting with a slightly different perspective, and it's sort of a perspective of sort of let's not lose sight of the charitable activity in all of this. And we can talk about more of that in a bit when we talk about the bifurcation of how America approaches charities regulation. But Mark, well, let me just turn over to Mark on terrorism, and because I think you've seen it from the other perspective.
The other perspective.
Well, another perspective, a different perspective.
The terrorism issues involving charities at one time involved money, and certainly it's money now is the focus, but there was also a time where it really was the movement of weapons. And that was distinctly different from money. And it also involved transfers among the common law jurisdictions, raising money in Boston and New York for the Irish Republican Army, to fund violence in Ireland and then in Northern Ireland, raising money to fund violence in South Africa and in the Portuguese colonies in Africa, in Nigeria and the Biafran wars. Weapons were smuggled under the guise of transferring aid, transferring medical supplies, things of that nature. And that still occurs. But at the moment, the focus is on the transfer of money, because money is easier to track than cheap weapons. And so the regulatory mechanism that the U.S. has created with the Financial Crimes Enforcement Network is tracking money very precisely. But money isn't the only way that terrorism is spread. And in the wake of 9/11, the Treasury Department grappled with how to deal with that terrorist financing, with the money transfer, not so much the weapons transfer. And the approach that they finally settled on was to develop best practices for charities, which really ran to sort of governance and oversight rules. That is, you should have a board that pays attention to what's going on. You should have a board that tracks money that's expended, knows who receives the money, know your grantee sort of rules. And those were, because there was no specific statutory hook, the Treasury Department couldn't write rules and regulations that people had to follow. So instead, the route taken was this approach to issuing best practices. And that, I think, also created a bit of a diversion in the sense that, charities, I think, felt that they had developed fairly good controls and best practices. as a general proposition. They tended to want to know what happened to their money because they wanted it to go for the charitable cause, not for someone's expensive house or a villa on the sea or something of that nature. So there was a bit of a tension between charities being forced to accept best practices created by the Treasury Department out of essentially whole cloth, when they felt they were already engaged in best practices. And I think that approach seems to have dissipated a bit. I don't know what's going to replace it, but the sense is that there might be a realization by the Treasury Department that, at least as far as U.S. charities go, the diversions are occurring somewhere else. The money is leaking out of the system, out of the regulatory system in another way. It's not governance issues with the U.S. charities so much as perhaps these other devices that have grown up. Jim mentioned donor-advised funds. I think he had limited liability companies on his one of his sheets as well. I mean, those devices are typically going to, if they appear at all on a charity's financial records, the actual recipients, the owners of the money, the sources of the money, and the recipients of the money are all going to be very obscure.
Well, let me add that the other thing that falls into, or that was raised in a FinCEN report a couple of years ago, or a report to FinCEN from the U.S. government about the state of money laundering and terrorist financing. In the section on charities, there was a long discussion. There was a short discussion about charities because there hadn't been a lot of actual activity with charities over a 10-year period. But there was a long discussion of faux charities, folks that called up and raised funds claiming to be charities when they actually weren't. And I think this is really interesting because it's kind of that's difficult for the charitable community and the charitable sector to deal with because these folks actually aren't charitable. And the IRS doesn't really have anything to do with faux charitable solicitation. That's really more of a state level issue. Maybe the FTC.
It is the FTC.
It's the FTC, but they haven't been as active.
Right.
And it's been a difficult area for them to really get involved in, particularly because of the diffuse nature of charitable solicitation. So I flagged that because it seemed difficult in a couple of ways. One, because who's gonna find it? Number two, if they're not charitable organizations, then our whole system that's built on disclosure by charitable organizations to charitable regulators doesn't capture any of it because they're not in it. And third, it's damaging the reputation of the real charities that are going about their business, both with the public, if this hits the front pages, but with the regulators who are trying to crack down on charities and create more mechanisms to control charities when it's the faux. So I'm not sure how you crack that, but I did point out to the FinCEN folks that they seem to be at least two different things going on that may not intersect.
Well, we've long had the quandary of the true fraudsters that don't intend to do any of it by the book can escape all sorts of oversight for that very reason. So fascinating. We're going to have a chance, as I mentioned on Q&A, to actually ask about some of the substantive issues that we're talking about here, which may seem somewhat disparate, but actually they're all related in the same sense that they're transnational issues. They're being dealt with across the globe. Learning from different jurisdictions how they're handling things, seeing what can be replicated, replicate the good, and also connect amongst the regulators, which is why these meetings are so important. But we're going to talk now about some of the issues that you see, and you started to touch on that, around some of the challenges and the barriers that exist at the very time that we should be thinking about how best and most efficiently to actually work amongst regulators across the globe. Given that philanthropy, and we're going to discuss that, actually charitable solicitation is not one of our topics tonight, but we're going to touch on this briefly at the end with some information for those of you interested in global philanthropy, is at a high So what do we do with that in terms of regulation and oversight and thinking about the money flows? What are the barriers and challenges? And I think we're going to start with, is it Ruth? Yes, Ruth again.
Yeah, so I was asked to talk a little bit about the barriers and challenges that I saw from a position at Treasury. And in our system, for those of you who aren't familiar with how we regulate the charitable sector in the U.S., it's a bifurcated system. States attorneys general have authority, typically attorneys general or other charity regulators, but they have authority over the organizations in their states because they are birthed, they are created under state law as nonprofit organizations. At the federal level, we don't have a nonprofit code, and the organizations are not chartered at a federal level. And for a long time, state law was state law. We had you did a great history, going back, and the different jurisdictions had their charities, and there were charities in America long before we had a tax code and long before we had a 501c3. So a lot of times folks don't realize that's a tax code section that is being quoted all the time. And I remember when I was in law school, and I was very interested in community economic development and charitable organizations, and I found out, well, if you want to do that, then you have to become a tax lawyer, which seemed odd at the time, but I accepted it, and I became a tax lawyer, and I practiced tax. And 10 years on, I got to Treasury and the Office of Tax Policy, because, of course, if you're a tax lawyer and you're going to make policy in tax, you go to the Office of Tax Policy. And it was there that I realized, you know what? A lot of my time spent in private practice up until now was not doing tax law. It was doing charity law. I was advisor to charities. And there's a lot about charities apart from tax. And tax policy kind of is tangential to tax-exempt organizations because they're not paying tax. And it occurred to me that what we're doing in our tax code is regulating charities. And if you look at the provisions of our tax code, America, they do a lot of the same things at the federal level as at the states, but they do it in the form of, they just crush it into excise taxes on bad behavior that you're not supposed to do, so that those taxes never get assessed, in theory, unless you do something bad, and then it looks like a penalty. So at the federal level, having the regulation of charities forced into a tax box has some odd consequences. And I've heard Mark speak about this. In fact, it was from Mark that I first learned this when we were practicing, that you can force a lot into a tax box, but what we're ultimately doing, even when we're talking about excise taxes, is what we're regulating behaviors, thou shalt nots, which is really much more easily addressed at the state levels through immediate powers to go after bad actors, rather than in a tax scenario where you file tax returns at the end of the year, 11 months after the end of the year, and then they get put in Ogden, and you see those returns sometime, later on. But at least what it does do at the federal level is it provides a window, and it creates a system where everybody's reporting in the same way. And at least since 1913, when we started to have since we have an income tax and the tax exemption, the IRS functioned as a gatekeeper of sorts. You can see early decisions going back into the 20s where the IRS was requiring a few bits of information from charities to prove up that they were entitled to the exemption from tax. Things like projections of financial, what your projections were going to be, a narrative statement about what you were planning to do, and then budgets, essentially, saying where you're going to get your money and how you're going to spend it. And as we came through time, the IRS developed forms to collect this information and to act as the gatekeeper, and the Form 1023 application for exemption became a gatekeeper for letting people into the coveted 501c3 status, right? And everybody knows that code section, not because they're tax lawyers, but because you get the federal tax deduction for contributions to those organizations. And those are in the tax code. But what I realized you realize it when you're assisting organizations that the tax benefits are not the only benefits to that to the 501c3 status. There are postage, mailing benefits that you get. There are state level benefits that often piggyback on top, whether it's income tax exemption, state sales and use tax exemptions, property tax exemptions, which may or may not line up completely. But there's a lot piggybacking on this determination of 501c3 status. And it's not only at the state level, it's also at the federal level. And I started finding, as things started to hit my desk from all around, and as I was there longer and folks realized, oh, there's someone who knows something about the charitable sector at the federal level, at Treasury, I would get calls from the Department of Education. And some of their certification or their licensing statutes that allow for a more lenient regime for colleges and universities to be able to get federal funding for their students. It's easier if you are a nonprofit that basically is a 501c3 because their statutory language mimics the 501c3 language, and they would, in practice, look to the IRS's enforcement of C3 status to determine whether this organization ought to also get priority and beneficial treatment in education licensing. The State Department had some visa. There was a State Department visa program that came through, and it had a special category for 501c3s. So I thought, oh, that's interesting. I had no idea that was there. The bankruptcy code. You're going through personal bankruptcy, you're required to go get credit counseling from a 501c3 credit counseling organization. And so if you're a credit counseling organization, it's better to be a C3. And the Department of Veterans Affairs has grant programs. I saw one of these come through, whereby C3 organizations that will do upgrades on a veteran's home can get funding from the Veterans Department. So it's a grant program and access to funds. All of these different things hinge off of this C3 status, which the IRS determines using the 1023 form up until a few years back. A few years back, some of you might be aware that there was a little kerfuffle at the IRS. And I'm not going to talk about the political allegations that were flying around, but one of the things that really, the fuel on the fire there, was that a number of applications had sat around in the processing, and that there were a number of applications that were taking more than a year to process. So limited IRS resources means increasing pile of applications for exempt status, and the match was a political environment that made it easy to cause a conflagration by accusing the IRS of impropriety. So the whole thing starts to burn, and the IRS found itself under fire, hemorrhaging and having a hard time doing its main job of collecting taxes, because a small piece of the organization was being targeted and was at the center of this controversy. So the response from a rational administrative agency with limited resources was to create the 1023EZ form. This is a little more detailed, but I'll draw it back out in a minute to let you know why it matters about forms. This form is, as its title implies, easy. It is easy to fill out. Every single one of you could fill out that form in about 15 or 20 minutes if you wanted to, because it's very clear what the right answers are if you're a charity that wants tax-exempt status. And the likelihood of you getting that tax-exempt status letter, that is your ticket to all of these benefits, is about 99% within about 4 weeks, 3 to 4 weeks. return mail is basically what happens. 1% is looked at before it is stamped approved, and the rest are maybe looked at later. But there is the gate that was being kept by the IRS has gone down markedly. That's had impacts at the state level. I think a number of state regulators are starting to see that the IRS gate is not shut so tightly. And I wonder if this also has international impact. I know that treaties have provisions specific to 501c3 organizations. I don't know the extent to which American 501c3 organizations get benefits in other countries or presumed to have a certain status, but it would be something that would be worth looking at, because I don't think that at the federal level things are quite as tight as they were, and the IRS is not viewing its job anymore as protecting the integrity of the tax-exempt sector. It has refocused on its primary mission of collecting taxes. And you can see that in work plans, and I feel weird sitting next to you talking about work plans, because Mark really is the one who studies these things and knows these things, but the work plans are now focused on things like, are charities paying their employment taxes? Are charities calculating their unrelated business income tax appropriately? And are maybe not focused on some of the things that are more critical to the health of the sector. But that, I guess my role here was just to explain that there have been changes, and those changes may have far-ranging implications, not just at the federal level, but at the state level and potentially at the international level.
Thank you, Ruth. Before Mark, I ask for your opinions on this as well. I mean, I think it's, to your point, the real point here is that it's not just within the U.S., but because the U.S. has such a giant footprint in the philanthropic sector, there is no doubt about that, and just in terms of dollars. There's an ecosystem that has been built up over time around what was a regulatory framework that we had, and the query is, as that changes, what does that mean for the international community that relied in some sense on making sure that the U.S. at least was keeping the gate in their own shop, if you will. But it helps in other places too. And it also means what will it mean for, the countries like Sarah's operating in, where they may need U.S. cooperation on different issues as we continue to globalize and continue to go across jurisdictions. Is it going to make it tougher? Do we lose street cred as a country when we can't even answer some of these questions within our boundaries and within our own jurisdiction? Mark, do you want to address some of the holes that you see as a result of this that may impact internationally?
Well, certainly, Ruth talked about the front-end enforcement, that is, the kind of filing that new charities have to make when they get started. But there's also the annual return filing, and that's what I'll call back-end reporting. And there, the IRS has also simplified the filing scheme. For organizations that believe they are going to remain small, and I think if you look at the history of fundraising abuse, you'll find that most of it occurs in smaller organizations because they don't want to be around a long time, because they can be traced. So you spring up like mushrooms after the rain, and then the sun comes out and you disappear, and then there's another storm and you spring up again. So it's a bit of a cycle, but you're always small, so you stay under the radar of filing the application for exemption, and now the IRS has made that easy. You don't have to worry so much about that. But also on the reporting side, there is a reduced reporting burden for smaller organizations. In fact, you only have to file a postcard announcement or notification of your continued existence every 3 years. Form 990N, basically an announcement that you still are around. And if you don't file either the full 990 series forms or the Form 990N, After 3 years, your status is automatically revoked. The IRS computers will do that for you if they don't notice the filing. But if you are intent on scamming, if you're intent on committing fraud, that's a wonderful device, because after 3 years, if you don't report, the IRS ledger is wiped clean. So the IRS has 3 years to find you, and you get your certificate to go forth and hold yourself out as a charity by filing a registration statement, and then you don't bother filing the returns, and oops, after 3 years, all over. Except it's not, because you've managed to raise money for 3 years before you were before your status was revoked. And of course, there's the registration process can be renewed in a new jurisdiction. So the absence of data flowing after that exemption effect, I think, is being manipulated. And certainly what I am seeing that happen is in the world of politically oriented organizations, where the election cycles, 3 years is a pretty good run for an election-related organization. Not having to file those pesky returns that disclose who your donors are and where your money's going is a huge advantage. And I think if you read the tax press closely, you might have seen a few examples that are reported as enforcement victories by the IRS, when what really happened was the organization lost its status for failing to file returns for 3 years. There was no enforcement action. The IRS computer just tracked the lack of documents. So the absence of reporting, I think, is becoming a significant issue, both the front end and the back end reporting. And I think we're just beginning to see the manipulation of that.
So I have a question for Sarah, or for any of the other international regulators in the room. What do you wish other countries, and by that I mean the U.S. But what do you wish? Are there areas around regulatory enforcement or regulatory framework issues that you wish were changed or different that would make your job easier as a smaller country, smaller jurisdictions, but that are still dealing with these, grappling with major issues?
That's a good question. So I think one of the fundamental differences across the different jurisdictions is your tax and your charity status united or separate. And I think that's got, in many ways, that's kind of the most fundamental division, where it's separate as it is for us. So there's the UK Tax Authority, HMRC, and then us as the regulators. The benefit of the separation is that we don't have any financial incentives to make a decision either way. We don't, whereas HMRC is motivated to hold on to that tax revenue, not give that tax exempt status away. The decisions that we make that trigger tax exempt decisions are made by us independently and separately, and they're about status, they're about law. And that separation is helpful, but where we're starting to have organisations that are operating across multiple jurisdictions and are going in and out of different setups where that tax status is made in connection with the charity status, that's where things start to get complicated. So we are seeing organisations that have charity status, tax exempt status coming into our country, wanting the same status. The decision making is complex for us, and the extent to which they've already got that jurisdiction, that approval, and want and are able to use that as a pass to explore things is challenging. So I think that feels like the tension, but that's there's a long, deep history about why those decisions are made in the way that they are. So I'm not sure it's a wish list, but it's a complexity. And of course we have, my country is still in the European Union, which we are.
U.S. time.
Across the across the EU in the same way, we've got most European countries are not common law jurisdictions. They have much looser concepts of what is and isn't a not-for-profit. But again, in the UK, the way that we're set up, organisations from across Europe can come in and claim the same benefits from the much easier setup. So that kind of jurisdiction shopping is actually quite worrying, I think.
I'm going to ask Jim to respond too, but do we have any other international regulators in the room that want to respond to this question of what could make your lives easier amongst the. Mhm. Mhm.
Investigate that because 28 million pounds of funds raised in the UK is a significant amount of money. But actually, your ability around those organisations is also severely limited. So what we've found is actually a closed door. If it's a religious organisation, it's raising funds in the UK, we have significant concerns and do not believe those funds are being used for charitable purposes. There is no way for us to pursue it with you, and you're limited as well. So for us, that's a major issue.
Janet, next to you, has a thought.
Okay, well, it was in Texas. That explains it. Well, because Texas doesn't have registration. It's not a registration state.
Right.
If you're in Tennessee, while you don't have to be, a religious organization doesn't have to be registered, you're not exempt from the deceptive fundraising provisions. And so if you were raising that money and saying it was going to be used for a religious purpose, but you weren't using it for that religious purpose, you would not be exempt from our statutes, and we could go after you. But Texas is not a registration state, so sorry.
And you can find that information on Urban Institute's website in the legal compendium, where we have a complete listing of all the different registration statutes for all the U.S. Jurisdictions, including the territories.
Just to add to the confusion, in New York, religious organizations are totally exempt from the registration as soliciting organizations and for all the other provisions of the soliciting statute, all the anti-fraud provisions, the entire statute.
Well, and that's even a further complication before I hand this to Jim, is that, of course, all the states get to decide exactly what their registration laws are, and the DC and all the territories, and they can all be different. The beauty of our federalist system at work.
We do have another statute that gives us jurisdiction, but we don't have the specific jurisdiction of the solicitation law.
Jim?
So I thought I was going to disagree with Karen, which is always entertaining because we work together every day. I think the interesting thing about religious organizations in the United States, it's pretty clear that under our First Amendment that you cannot tell them what ministers to hire, and you cannot tell them what doctrines to follow. If they want the tax exempt status, it's within the First Amendment to say you have to register, because that's the benefit you're asking for. One of the things we have in New York, which is very effective, well, we're going to find out it's very effective in the Catholic Church investigation, is if you want to be a church in New York and you want the benefits of being a corporation, you actually have to file for registration as a religious corporation. And we have a whole variety, we have 12 articles, and it's more complicated than you ever want to hear. But so part of the theory in the Catholic Church case is every diocese is registered as a religious corporation. And there are certain exemptions from our statute, but it also says the stuff that applies to fiduciary duty and responsibility applies to you. So the 5 members of each of these corporations, 2 lay people, the bishop, the vicar, and I forget who the 5th one is, they are bound by those same rules. And so that part, I think, there's no question if you look at religion in the United States, there's been a tremendous reluctance, apart from the Constitution, by regulators in touching that. And Janet, you talked about, well, if they're in Tennessee, we'd go after them, but how many churches have you gone after in Tennessee? But you have these other churches.
You don't have to be incorporated. You can choose.
Right.
And we have a lot of churches in Tennessee, but a lot of them are not incorporated. And so in that instance,
But In New York, I don't think we were disagreeing. I said there was other statutes that give us jurisdiction, but California is interesting because the Attorney General is specifically barred from jurisdiction over religious organizations. So, as we've been discussing today in the conference, the states vary a lot.
Well, and to the point that we're talking about the intersection with the international piece, I mean, it just goes to show we've got any number of issues that cross borders that really don't care about the borders. I mean, the borders are political designations. The Catholic Church or any other church, and even the manifestation around, for example, money laundering, terrorism, these are borderless by their nature. And really, the issue here is how our regulators that are bound by their jurisdictions and the laws that they have, whether it's all the different laws within the states of the U.S. at the federal level, or the other countries that have their own, different provinces, all, and again, we have a limited number even of the regulators here. The world over, we have very many different regulatory frameworks and regimes. The issues that you're dealing with now don't care about borders. So what do we do as regulators who care deeply about borders and in fact are constrained by them?
I think also, correct me if I'm wrong, Tony and Sharmila, but I believe in Canada, churches file an information return, the T3010, do they not? The equivalent of the Form 990. So there's a completely different form of financial tracking going on. Some of the same churches may have operations in both countries. One country they're reporting, and the other they aren't.
Comments from the panel before I open it up to the audience? Oh, we've got a mic going around. At least one, maybe two? I think we might have two. Let me see so I can see folks here. All right, we've got a question in the back. If you could let us know, name where you're from, what
Of
organization or space in your life that you're interested in this.
I'm Regina Johnson. I'm an educator, and I'm currently a high school principal. This question is for Jim. I want to know, based on your presentation and your professional experience, would you say that the charitable sector has been infiltrated by capitalist bad guys, or that the charitable sector has many of these same elements that are coming through and becoming dominant or clearly seen when you investigate these things, or maybe neither?
So I operated in the theory that human nature is everywhere very similar. And one of the things in the American culture is, if we talk about metrics, but watch what you measure because that's what people will respond to. I think larger and smaller organizations are being encouraged to be entrepreneurial, and that has some consequences. And then when you start to think about being entrepreneurial, part of that is how do you respond to donors, how do you respond to donors' desires, and how do you accommodate them? And that's always a tension in charities because we say you can't have a private annulment or a private benefit, but at the same time, money corrupts to some degree, but it's part of the process, and you got to recognize it's a reality. So I don't think it's an issue of big money corrupting charity. I think it is just human nature responding to these situations. And what we've seen in the donor-advised world, to some degree, is if I'm running a donor-advised fund, and last year I had $10 million in the fund, and I want to have $50 million in the fund, and there's a big donor who says, well, I want to create scholarships for my 5 nephews, but I need you to give those scholarships to the nephews, there's a strong temptation there to create the scholarships, even though that's private benefit and it's illegal. I think whenever there's money involved, you're going to have these risks, and part of the regulator's role is to say, okay, we want to give you the opportunity as an organization to say you can't do that. And it may be the auditor, it may be a board member, but that's why we have this institutional structure to prevent those things which are natural tendencies from happening.
Another question in the back from one of our J School colleagues.
Hi, my name is Andrew Calderon. I'm curious about the politics of these issues. So particularly, what are some of the lobbying groups, or who are some of the politicians that have been pushing to continue to deregulate nonprofits, and what can you say about that?
Okay, the intersection of politics and religion, and the intersection of politics and nonprofits is endlessly fascinating. So Okay. And one of the things that happens, so if you look at the politicians in New York State who've been indicted and convicted in the last 10 years, and there's a fair, as we say, it's a statistically valid sample. An awful lot of them are their vehicle of choice for the fraud was a nonprofit they controlled. Now, why was that? Well, I have a theory. If you're living in a wealthy community, there are all kinds of sources of money that you can take. So real estate brokers and lawyers and insurance brokers. Living in a poor community, there's often less of other resources available to run a campaign or to get yourself into office. So the temptation there is significant. And so we do see charities which are problematic, and usually we're called by the New York Post to say, what are you doing about this? We see charities that do some good things and some things that are more problematic. They let their phone bank be used for a campaign, and that's illegal under our state law. And there's a push from both sides. There's a push from the opposing politician to say, why aren't you going after John Smith because he's doing these terrible things? There's a push from the elected saying, look, I'm trying to run a campaign here, and if you try to run a campaign, it's a very difficult thing anyway. You're getting volunteers, they're doing things, you're trying to keep track, you're filling out your forms. So that regulation, deregulation push is significant. The other part of this that is significant is if you have a major nonprofit in your community, if you talk about where can I get things for the people in my district, very often it is that nonprofit. So, for example, managed care organizations that provide services to Medicaid people. And you say, I want a clinic in my community, I want these other things. That's okay. But that's okay under the law. And then the question is, what else do you expect? I guess it's a long-winded answer to the push for deregulation and the push for regulation come from often the same elected officials at different moments. The other part of deregulation of charities is what kinds of grants do charities get in New York? And there's several $1 billion worth of grants from the cities and the state that go to nonprofits. And after the grant comes in, what kind of controls exist, whether it's Charities Bureau or it's other state agencies to say, how did you spend the money? And there's significant pushback to say, should you look closely at that? And my own belief is if another state agency gives them the money, they at least ought to keep track of what happens to the money. That's their job. But you can imagine the politics of that are often difficult.
Question right here on the aisle.
My name is Corinne Varela. My question pertains to, since borders are a human-made concept and so is currency, how internationally, if there is an agency implemented, could there be preventing money laundering in a sense? In the future, it's a hypothetical question. And would there be pros or cons to implementing an international agency that could help prevent money laundering?
I know I'm being a piggy on that. Let's talk about, so the first thing is they are human concepts. You will always have money laundering. It's like sin, it will always happen. They'll just find different methods and different techniques. One of the interesting things about the FATF, which is the international organization created by the G7, is if you watch how international organizations work, they work by consensus, they work by agreed upon procedures. There's a balance between autonomy and regulation, which tends to fall on the side of autonomy. You don't say mean things about countries that aren't doing the job unless they're not part of the club. So if you look at the countries that FATF identifies as money laundering sites, Yemen, Syria, Iraq, they're not members, by the way, North Korea, the countries that have huge money laundering, and I look at the United States and the UK, you'll never see them on the list, and they all, on their grade sheets, it's all green, which is the good color for these purposes. So I think that the other thing, my point is that everybody wants, there are enough people who want money to come into their country from money laundering activities and benefit from it, that you'll never have a national or international regime that's effective at preventing it. And the question is, how much transparency can you get into that process to minimize it?
Ruth, do you have thoughts on this? Nope. Mark? The odds of ever having international coordination that goes beyond the lowest common denominator possible among countries?
Yeah, the difficulty is that it's like dealing with terrorism. Sometimes there are terrorists, sometimes they're not our terrorists. A perfect example is the Iran-Contra situation, for those of you who recall when Ronald Reagan was president, and the United States was interested in fomenting a revolution in Nicaragua, and Oliver North created a string of charities to solicit money to fund the war in Nicaragua, including meeting with wealthy donors from Texas in the Hay Adams Hotel in Washington, D.C., where he solicited money to buy surface-to-air missiles. So the difficulty with money regulation, with money laundering regulation, is sometimes the jurisdiction wants it laundered, like when it's coming in, or it wants to foment a rebellion somewhere and doesn't want their fingerprints on it. So sometimes the outflow becomes useful from a strategic standpoint. So the difficulty is it all depends. There's no clear distinction between right and wrong sometimes. It kind of depends on the political position of an organization and of a country.
There's a clear distinction between right and wrong. There's not a clear distinction between who benefits and who gets hurt, right?
Well, you know, in international politics, I'm not sure there's a clear distinction between right and wrong.
Other questions and also comments from our other international regulators who are around here as well. Be great.
Hello, my name is Honor Harlow. I'm a first semester student in the program. Question for Ms. Atkinson. So in your sector, you talked about how there is a lack of reporting, and then even if you had more reporting, there would be a potential lack of capacity. What are some solutions that you're finding that people are talking about in your sector for encouraging reporting and then meeting capacity once those reports come in?
So the first thing in terms of reporting is to give charities confidence that reporting something to us, reporting in a timely fashion, reporting in an honest fashion, isn't going to be treated by us as prima facie evidence that you have done something wrong or you are bad. To encourage that reporting is normal because things going wrong is normal, and organisations identifying that things have gone wrong is healthy and good governance. So that's the first thing, and we've been talking a lot, done lots of media and lots of engagement with the sector to say, you know, problems happen, you work in complex environments with sensitive issues, with human beings, I'm with Jim, human beings, things go wrong. So this will happen, this will go wrong, and you will report to us, and this will be a good sign. The next thing is to give assurance again that when charities report to us, and we may take some action, it's the way that a charity has dealt with something that will help feed into that. So when all of this happened in February and we had all the national and international newspapers and broadcasters on our tail saying who else has reported things and what have they said and what have they done and which charities reported, and we were very strong about saying, actually, we're not going to tell you that. We'll tell you when there's enforcement action taken, but we're not going to tell you who's reported what. We're not playing the game of saying this charity has reported 10 things, so 10 things have gone wrong in that charity. The third thing, which we're really working on, is trying to move away from every report means a case. And we will never have the capacity to do that. And even if we did, I don't know if that would be the right thing to do, because not every report needs to be a case. Every report needs to be a piece of data that we can use for intelligence to feed back, to strengthen governance, to strengthen auditors and professional advisors, and to strengthen understanding of what the picture is. But not every report needs to be a case. And that's a shift for us, because we're primarily a case-working organisation, and to think about not being a case-working organisation is a shift. It's also a shift for the sector and for the public and for government to understand that, but something happened. What have you done about that thing that happened? And for us to be confident about saying, we did a report and we've encouraged auditors to identify these practices. You know, they want a consequence. They want a person to be found accountable. So that's the longer term shift, but we think that's got to be the right shift. A healthy climate of reporting, honesty, transparency of disclosure, and then a systemic response to those kind of issues. Casework where something really a charity is unwilling or incapable of dealing with it, but intelligence and then action rather than action and then intelligence. That's the theory.
I'm going to weigh in just a second on this piece because I think the reporting piece is particularly interesting in our charitable sector and different in some ways that are meaningful than the for-profit sector on particularly two fronts. One is that we don't have a good system of whistleblowing. And frankly, the sector has not been invested in doing this. It's something that actually interests me on the legal front. We have, entire sectors. The SEC is a great example of having an actual whistleblowing system. It's not something that's been encouraged in our world. When we tried with Sarbanes-Oxley to import some of this stuff, that was rebuffed. My hope is that we build this in. It's a cultural shift for our sector to have whistleblowing, and this leads me to the second point. Reporting is kind of a trigger word, if you will, for some folks in our sector, because, of course, the main reporting that everybody does is to funders. And that's already really tough for some groups. It's a very painful experience for some. I actually believe in, having looked at a bunch of this over the years, is to think that if we change some of the system around funding reporting, we could be encouraging organizations to own up to something that's happened. Again, very similar to the SEC. It's actually incumbent upon you as an organization to report what you're seeing. And it doesn't mean that the regulator is going to hold it against you as an organization, nor, however, should it be held against you when a funder receives a report like that, right? That's one of the biggest problems. Nobody wants to report this stuff. The government's the least of the issues, actually, in our country, at least around most of this, because enforcement is very low on a lot of levels. The much bigger issue is that the funding won't come through again, right? Because you reported it. So I would just offer up that that's very different. We have issues in the for-profit or profit world where obviously companies aren't thrilled to have to report different things that have happened, but it is incumbent on them, and they can isolate it, compartmentalize it, deal with it. We haven't conquered that in our sector yet, in my opinion. I know we're at 8:30, but this group is so awesome up here. I want to make sure that we get to a few more questions or reactions. So we've got program student here first, and then we'll come up front.
Hi, my name's Kelly. Thanks for being here. I'm really interested in the quote-unquote overhead ratio, and when I was in the program, did a lot of research around the pressure to keep it low and the negative impacts that can have. I was just reading that in the for-profit sector, an average the average corporation spends around 35% on those overhead expenses, while a nonprofit spend around 2%. So huge discrepancy. So I'm interested to hear if that, donors' hesitation to keep that ratio low, or to donors' hesitation to fund those critical expenses like technology, professional development, is that a U.S. thing, or would you say that's universal?
It's absolutely universal. Funders want to fund new projects and programs, not ongoing activity, and they want to fund new activity, not core. And certainly in the issues that we're describing, and safeguarding and strengthening governance and reporting frameworks, we the regulators and DFID as a funder themselves have done a lot of work with other funders to encourage them to make clear that these are not optional costs that you hope that you will afford as part of what you do. This is what you do. If you can't keep people safe, then you can't deliver the program. It's completely integral. I mean, absolutely, in the context of international aid, if you can't guarantee you won't do any harm, don't get into the program in the first place. But it is a challenge. It's a challenge to get funders to engage with that, and it's also a challenge to get charities to shift that. So even where the funder isn't explicitly saying, I won't fund your core, charities themselves are thinking of this as something that they must cut, they must reduce. It must all go on the end result, and not themselves thinking, well, what is the end result if it's not keeping people safe and improving beneficiaries' lives?
Yeah, and I would add on to that, I mean, yes, keeping people safe and improving beneficiaries' lives, but being good at what you do requires some level of investment in overhead, right? It's not that for-profit companies are investing in overhead just because it's fun. It's because it helps them be more effective in accomplishing their mission and making more money, right? They know in the for-profit sector you have to spend money to make money. You have to have the computer systems that allow you to be efficient if you want to, make more widgets. Or, and I think that charities are sort of behind the curve on some of that stuff. I mean, in a good way, charities and those of us who deal with them are penny pinching, right? But when you pinch pennies, sorry, you end up eating into your ability to actually accomplish the purpose. And so things like paying the lowest salaries doesn't really help you if the people that you hire can't do the job as effectively as someone that you paid a little bit more, or not investing in technology, not investing in systems, not investing in reporting, so that you don't have the data to know what you're really good at and what you're not really good at. I think that's a general problem. I think it's really interesting, speaking of reporting, hearing you talk about this reporting theory. It involves a lot of trust, and I think that you can have that if the regulator has the purpose of having a healthy sector. And one of the things that I think may be a difficulty, especially with, at the federal level, the IRS refocusing on tax collection and just the fact we're just here to enforce the statute. We're not interpreting it. Our hands are tied. If you report, we have to give a consequence. And I think that there has been a shift. Certainly in working with Mark over these years, we worked together. We've worked together for over 10 years, right? Mark felt when he was the regulator, there is documented evidence of the discretion that he had to craft, or that he felt he had and that he utilized to be able to craft remedies and to be able to reach enforcement decisions and solutions that made for healthier charities. Yes, revocation is an option, right? If you miss your requirements, revoke, you're gone. But the truth of the matter is that the community needs the charities, right? They're doing important things, if they are. And in a lot of cases where there have been things go wrong, they are needed. And revoking them hurts the community more. And I think that there's been a shift to not seeing that sort of robust picture of the benefit of the community at the federal level.
Well, our sector needs infrastructure, from the organization infrastructure to the regulatory infrastructure, and that's one thread that we have here tonight. I mean, I often say no donor says, hey, sign me up. I want to pay for the CPA that does your audit. That's not how it works.
The federal funding has been very difficult with that.
Exactly.
I think,
government contracting. Exactly.
The overhead amount allowed was, I believe, 10% for a long time.
Everybody's penny pinching, and this is what happens at the end of the day. And when you combine it with regulatory oversight that may be less than it used to, or the gatekeeping function is less, you've opened the floodgates in some ways. Another question? Oh, yes, we had one here up front. You? Yes.
Oh, there it is.
David?
Hi, I'm David Robb. I'm from Scotland, and can I thank the university and the panel for a really interesting session. I'm not sure if it's the hospitality or the jet lag that's kicking in, but I'm still alert and really finding this stimulating at the end of quite a long day. So my question is really about the globalization angle on this, and there's maybe a little irony that we're almost beginning to talk about the post-globalization era. We'll see if that's a thing, but I just want to ask the panel if they have any views about what we can learn from other areas where there are transnational issues. So if this is about activity that's really disregarding boundaries, what could we learn from the way climate change or other global issues have been tackled, or looking at just commercial companies who are kind of, they have no physical assets. It's all in the cloud or in the ether, and the issues that we have around getting compliance on taxation for that kind of international commercial activity. How do we get instruments that can deal with those kind of issues? Are there lessons that the charity sector and regulation there could take from other sectors?
Well, and it'll be interesting to see if any of you can come up with a positive example about that. But we certainly have an analog. Another example around, it was mentioned around Bitcoin, is the notion of completely the deregulated, decentralized, completely dispersed, which is the whole point. That's the nature of it. How do you, I mean, truly boundaryless, right? But any examples that you think work? I don't know that we can go there on climate change as a positive example right now. Anyone else have an idea? All right. Looks like Francis is telling me we have a question here from the folks out in the webcast land. Thank you. Donor advised funds were mentioned a few times as vulnerable to money laundering or to be used in other undesirable ways. Is this truly how DAFs are viewed by regulators?
Okay.
Every institution has within it the possibility of abuse, whether it's the Catholic Church or a donor advised fund or anything else. And so what we look at as regulators is to say, okay, what does this organization do that you can't have done in other places, right? So the donor advised fund is a structure created by the Internal Revenue Code. It exists. It's governed by those rules. Now the question is, what kind of abuse can you anticipate? What issues do you see? So donor advised funds, I'm agnostic on whether it's better to put money in donor advised funds or to put it into the charities directly. Actually, I'm not agnostic on that, but the law is the law. But the issue is, what kind of abuses are you going to see? And if you have a organization that gets lots of money from anonymous donors, then pays it out to other people, and has no anti-money laundering requirements under the statute, some people are going to find that structure and use it. So our goal within the New York Charities Bureau is to say, what are best practices? I know best practices didn't get a good review here today, but what are the best practices for the DAFs that care about doing a good job? And then how do we distinguish between the ones who are doing that and the ones who aren't?
And I would just add a different perspective coming from the federal. And while I was there, we did do some thinking about the regulation of donor advised funds, because the donor advised fund regulation, that their statute changed and added them to the code about 10 years ago, and we're still trying to get to those regulations. But the thing that I see a positive there, quite frankly, and I think it's really interesting to look at the notice. There are some concerns about donor advised funds that arise in the academic context, and there are other concerns that I think where, from a regulator standpoint at the federal level, a lot of the restrictions on private foundations were put in place because of concerns over donors that took their money, took a tax deduction, put it in a private foundation, and still had the checkbook, right? The money went from bank account 1 to bank account 2, and the donor still had the pen on both sides of that transaction. Or real estate, the donor had the real estate, they gave it to the charity, and they still were the ones who could sell the real estate to whoever they wanted. That doesn't exist in the donor advised fund context. And so at the federal level, I was less worried about the transactions where the donor has control on both sides of it. You've got a third party involved. And when you're dealing with donor advised fund sponsors like Fidelity or Schwab or even large community foundations, they don't care who you are. They're not going to risk their tax status, their jobs, their business model to let you have that pen back to that account. And so the likelihood, what we seemed to see, and what dealing with the IRS, we looked at, donor advised fund where you have a bunch of people with, $100,000 to $20 million, putting it into accounts and saying, I really kind of like it to go there. And a third party, the fund managers that were actually controlling the assets, versus a whole bunch of little tiny private foundations with not a lawyer in sight, not an accountant in sight, but the donor, their family, and their checkbook pen. And as just a where are there going to be more mistakes made? Where is there going to be less understanding what the charity rules are? I'm going to bet that Fidelity, I don't know Fidelity, I haven't looked, but or any of these large organizations with lawyers on board are going to know the law a whole lot better than a whole bunch of these private foundation folks that have never really looked at the charity law. So there's different risks and enforcement risks, I think, with different structures.
I was going to give our host state the last word on this. We could have, of course, there have been many conferences on DAFs for this very reason. Jim, closing thoughts on this piece?
So I think what Ruth just said is they're not as bad as private foundations, and that's probably true. But if that's your standard, that's not a great. To me, that's not a great standard. If private foundations have had that situation, I think, because there's been reluctance by the IRS to look very closely at them for a very long time, and there are various reasons for that. I assume one of them is efficiency, and there's been reluctance by the states to look at private foundations too, because they all have the option of going to Delaware, where they disappear without a clue, or any sight after that happens. So we are not against donor-advised funds. We just think they ought to run in ways that sound like what Ruth thinks that the major ones do. And it's a new model, it's a new business, and there are incentives that are problematic, and it's a question of saying, what does fiduciary duty and reasonable prudence require in those situations, and making sure they do it.
All right, a couple more points. I thought of a potential example, even though it's not going to be perfect. Human trafficking. We have more going on now with the way that we do cross-border human trafficking and working among international regulators on both the civil and criminal. It's gotten better than it used to be. And unlike Jim's example of everybody welcomes money when they're not the recipients of the laundered money, maybe this isn't the case. Mark's example of it depends on who the terrorist at any given time. The general notion, it's a lot harder to accept human trafficking and say that we're happy to have all of that within our borders. But there are some models out there of international community working on human trafficking. So I'm just going to offer that one up. Last thing, you'll note that we did not talk about charitable solicitation, cross-border jurisdictional issues around solicitation, where that kind of money is flowing. I want to bring your attention, the renowned Indiana University's Lilly School of Philanthropy has done a huge study. My students just heard about this week, the global philanthropy indices, and I want to bring this to your attention. It will be on the slide deck that gets sent around to all of you who've registered here. But for those of you interested, they've taken years and went in country to 100 different experts around the world. And if you go to this website, you will see that they have done an index around how easy or difficult it is with the barriers around philanthropy all over the world. And to me, this is a really interesting starting point for regulators to be thinking. And one of the index points was around regulation and regulatory barriers. And IU already has the list of all of those experts in field, in country, that participated in this survey. Dr. Una Osili, who was our masterclass speaker last spring, headed up this study. The link is in there. It is a fascinating report. There's also a short form of it that you can look at. But I bring that to your attention because we did not talk about solicitation tonight, per se, which is always one of the more popular topics in the rest of our discussions out in the field. But we do even have folks doing deep dive research on that aspect as well. And I do, again, believe that the regulating community could learn a lot from this research, and I've talked to Dr. Osili about that. So that will be also in your materials. We've gone, of course, way over, and folks who know me know I'm usually very timely, but I love to have this crowd together. I want to thank everybody for coming out in this horrendous weather, but this has been such a delight for me. I've learned so much this evening, and I hope this crowd continues to talk. We want to see you again. February 28th is our nonprofit open house. We'll be at Casa Italiana, which is on campus, a beautiful venue. You'll all be welcomed back. I want to thank all the regulators and our host AG State, New York, for the conference that's here this week. But I particularly want to thank all of you as panelists and for getting up here and hanging in for this whole time. So thank you so much for this. And to our webcast land, this is recorded, so anybody will make available how it is that you can get a link to this webcast, and we hope you utilize it for lots of different purposes. So thank you all, truly.
And thank you, Cindy and Columbia, for setting this up and hosting us, and it's been wonderful. So thank you very much.